right.
No.
Yes.
Let me confirm that the Facebook stream is working, and then we'll be ready to go.
Okay.
All right, we are good to go. Let's get started.
Okay.
Well, thank you everybody for joining us, those that are on Zoom and those that may be watching on Facebook. So we are collaborating with Colorado Legal Services with Andrea. Andrea, thank you so much for being willing to do this and offer this topic for the community. We really appreciate it. And it's a topic that I'm really excited about that we can talk about tonight. And do you want to introduce yourself a little bit?
Sure. My name is Andrea Rosenberry. I'm a staff attorney with Colorado Legal Services. I've been with CLS for about 6.5 years, and I practice in the areas of family law, eviction defense, bankruptcy, consumer protection, and some estate planning light. So I'm a bit of a crazy cat lady. So this is an issue that's near and dear to my heart. I've maybe spent a little bit too much time. I've had a couple cases where I ended up on the phone with shelters trying to find places for my clients' pets when they had too many or when they were having issues with their landlord. So I'd like to prevent evictions based upon on those kinds of issues. So I'm happy to be here. Well, be here.
Right, in the world of doing Zoom meetings, right? Yeah, well, thank you so much. Sounds like you have a lot of great experience. And so, you know, at Roice-Hurst, we often get a lot of calls about service animals, emotional support animals, people asking us, like, what's the difference? And we wanted to do this because it is an important topic. And a lot of time, I think there's confusion among just everyone, like, what is a service animal? What is an emotional support animal? Because they each have legal rights, right? They're both different. They fall under different laws, different categories. And I think whether you're a tenant, you're looking for housing, you're a landlord, a property manager, or maybe you work in a field where you help people find housing, I think this topic is going to be really valuable information. So we can go ahead and get started. Andrea, you prepared a really great presentation for us. So looks like everybody's on mute, which is perfect. And if you have questions, we'll just save those till the end of the presentation, and you can just pop them in the chat box afterwards.
Okay. All right. I'll share my screen. All right. Is everyone able to see the presentation?
Yes.
Okay. We've already kind of introduced ourselves. So yeah, I'm going to be talking about the difference between emotional service animals and emotional support animals, verification requirements for service animals, the Fair Housing Act, which is where we get the reasonable accommodation request, the process for the request, what landlords need to do, what tenants need to do, and some causes of action tenants may have if their request is unreasonably denied by a landlord. So I'm really so both the Fair Housing Act and the laws defining emotional support animals and service animals, they cover a lot of things, not just can you have your animal with you at your house, can you have an animal in your apartment if the unit or the building is in no pets unit. So I just want to define the difference between emotional support animals and service animals, kind of talk about that in general, but it's a pretty big area of law, so I have a limited knowledge and experience about you know, the travel requirements for animals, you know, actually training a service animal, those kinds of things. So just going into the difference between service animals and assistance animals. So service animal is specifically trained to complete certain tasks for a person with a disability. And that animal is trained to complete, like to assist that specific person. So it's not like you just go to the service animal store and, you know, they just have seeing eye dogs. You can, you know, I'll take the yellow one. The animal is, you work with a trainer and the animal is trained specifically for you. We have, you know, seeing eye dogs or, you know, seizure awareness dogs, and those animals are trained to serve people with specific disabilities, but within that context, the animal is designated specifically for that person. So like you can't just like lend another person with epilepsy your seizure dog, right? And the law regarding service animals says that they can only be dogs or miniature horses. So you can't have a service python or anything like that. Assistance animals are defined by a completely different set of laws. They're defined by the Fair Housing Act. And they're animals that help a person with a disability alleviate symptoms of their disability in their home. So one important thing to think about is if you have an assistant animal, you may be entitled to protections and a reasonable accommodation request under the Fair Housing Act, but that doesn't necessarily mean that you can take your assistance animal to the grocery store with you or other public places with you where animals aren't normally allowed or permitted. If an animal is specifically a service animal, yeah,
sure. Open real quick. I also just wanted to, going back to the difference between service and emotional support animals, one thing is that I hear often is that people will go online and purchase a service animal registration, and those are actually scams. I think it's important for people to know that because there's no such thing as something where you can just go online and purchase a certificate that says your animal is a service animal. I think that's just something important to keep in mind if you have a service or an emotional support animal.
Yeah, that's a really good point. Actually came up in one of my divorce cases where the adverse party was trying to say this dog was a service animal. And yeah, he had like the USA service animal, like whatever photo ID thing. And I was like, if you don't, you don't have like the training and everything like that, this is not a service animal. So yeah, I think that's a really good point. Yeah, you should be working with a trainer, and obviously you need to compensate the trainer, but there's no license or certificate that you need to pay for in order to have a service animal. And if someone is asking you to pay for this, yeah, that's a really big red flag that it's a scam. So yeah, it's a good point. Okay, so specifically talking about service animals, and this is just in the context of like you're in the world with your service animal who fits the legal requirements for a service animal. You know, like let's say you're at the grocery store with your seizure dog, and someone comes up to you at City Market and tells you need to leave because there are no pets allowed in the store. Like how should that interaction go? So if you have a service animal, so that's an animal that's specifically trained for you to complete a specific task, you can only be asked if the animal is required because of your disability. You don't have to tell the person exactly what your disability is. You just have to say, yes, this animal is required because of my disability. And then you have to tell the person what tasks the animal completes for you. So in my example, like if you have epilepsy and you have a dog that, you know, senses when you're about to have a seizure, that, you know, you don't necessarily even need to say, you can just say, I have a disability. This dog senses whether or not I'm about to have a seizure and, you know, gets help or, you know, helps me take appropriate measures for that. if it is readily apparent what your disability is and what the animal does for you, you cannot be asked. So if you have a disability that's readily apparent, like let's say you're blind and it's apparent because of the other aids that you use that you have this disability, and you also have a dog with you, I think you can argue that you don't need to tell that person, I'm blind, this is my seeing eye dog. You know, it's people that are disabled and clearly need the animal to be in the world and get the things done that they need to get done. They shouldn't be harassed by people who are asking these questions when they're obviously unnecessary. If you're out in public with your service animal, you're not required to demonstrate the task that the animal performs. So like if you have epilepsy, you can't be forced to have a seizure or something. Dog. Or, you know, if you have a seeing eye dog, you can't be forced to like do an obstacle course with your dog to show that, you know, this is a seeing eye dog. You cannot be required to provide a medical documentation of the need for the animal. And that goes back to what Ashley was saying, is if some company is trying to sell you this certificate that, you know, you need to have this if you have a service animal, I mean, that's a red flag, because that doesn't exist. And in fact, you can't be required to produce anything like that. And then, so if the store owner comes up to someone and asks them, like, let's say you have a animal that's not a service animal. So let's say you have an animal with you that's, when I was working at Target one time, some lady came in with a boa constrictor on her arm. Like, so let's say someone had approached her and said, hey, like, you can't have a snake in the store. And she had said, well, this is my service animal. Well, it's not a service animal because it's not a dog or a miniature horse. So that store owner could ask her to, you know, make appropriate accommodation animal. You know, you have to take the animal outside of the store, and then you can come back in and get the things that you need. So they can't exclude the person just because they tried to come in with an animal, but they aren't required to permit that person to remain in the store with the animal. Even if an animal is a service animal, if they're acting out of control, like they're barking at another dog or at another patron in the store, or if they're not house trained, like they have an accident in your store, even if they're a service animal, the store owner can ask that animal to leave. Like they still have to serve the person, but they can ask that animal to leave if the animal is out of control or if it's not house trained. Okay, so kind of moving into specifically how these things play out in the world of housing, the law that we have that gives us the ability to request to have emotional support animals in our homes comes from the Fair Housing Act. And so this is a federal law. So you have your federal law and your state law, right? So this is coming from the federal government. And it prevents discrimination based upon race, color, religion, national origin, familial status, and disability. So it prevents housing discrimination based upon these classes of things. Right, so, yep, that's okay. So we're gonna mostly be talking about discrimination based upon disability from the Fair Housing Act. So residents who have a disability, it makes it illegal for an otherwise qualified individual with a disability to not rent from a house just because of their disability. So if you have depression, you need your emotional support animal, which is your cat, to live with you to cope with your depression. You can't be denied housing on the basis that you have a cat, right? That's how we are able to craft this reasonable accommodation request. There are certain kinds of housing that they're not covered by the Fair Housing Act. And unfortunately, it's probably a significant number of landlords in our area. So owner-occupied buildings with no more than 4 units. So let's say you rent a duplex and your landlord lives in the other half of the duplex. That property would not be covered by the Fair Housing Act, which means that the landlord could deny a reasonable accommodation request. So if you were asking to move into a property that's a duplex that the landlord lives in the other half of, or it's a triplex or a fourplex, they don't have to honor reasonable accommodation requests. The other big one, which I think we have a lot of people that are renting, is single family houses that are rented by the owner. So let's say, you know, like my good friend has like 2 houses that she rents out and she manages them on her own. She allows pets. She's very accommodating, but they're single family houses. She runs everything herself. She doesn't go through a property management company. So she is not subject to the Fair Housing Act. So she does not have to honor reasonable accommodation requests. So if you're renting a single family home, but you rent it from like Bray Property Management or Real Property Management Now or some other property management company, that would fall under the Fair Housing Act. So if it's a private landlord that owns the property, but they're at an arm's length and they don't deal with any of the direct management, it's all done through a property management company, they're obligated to honor reasonable accommodation requests. But if it's just someone who's renting out their second or third home, they don't have to comply with it. The other exception to that is if you're renting out a house from a private landlord, but you're using a Section 8 voucher to pay your rent, the Fair Housing Act applies to you because it's federal funding that's paying your rent. So they need to comply with all of the Federal Housing Act laws, or they need to comply with all the Fair Housing Act laws and all of the federal housing laws to qualify for a HUD voucher if they're accepting vouchers. So I know we have a ton of people in the Valley that are just renting from private landlords, single family homes. Depending upon the situation, it may or may not apply to them, which is unfortunate. But I found that those landlords are sometimes the most reasonable people to work with. So, all right. So disability under the Fair Housing Act is defined as a physical or mental impairment that substantially limits one or more of the major life activities of an individual. It doesn't necessarily need to always be present. Like in the example I keep coming back to, if you have epilepsy, you know, you can go 3 years without a seizure if it's being well managed through anti-seizure medicine. That doesn't mean that you're not disabled under the Fair Housing Act, because it's episodic or it's in remission. It doesn't have to actually impair you all the time, or it can be an impairment, but if you are able to access reasonable aids, you know, you can function normally in society. So if you have, you know, medicine that you take that allows you to have a normal function, then, you know, you're still disabled under the Fair Housing Act, but, you know, it's being managed through a therapy. Okay, so reasonable accommodations in general. So this is just how it kind of works, like the broad picture. So let's say you're in a wheelchair and you need a ramp to access your apartment. You would need to do a reasonable accommodation request, and there's a process to approve that. And that's the same process that you would do to request that your emotional support animal live with you. So yeah, it's a change, exception, or adjustment to a rule, policy, or practice that's necessary for a person with a disability. So I don't know, perhaps, well, this probably wouldn't work because it's federal law, but yeah, like I said, if you have a wheelchair and you need a ramp to access, you know, the kitchen, and there hadn't been one historically in the home, you could do a reasonable accommodation request, as long as the accommodation is reasonable. Like you can't ask the landlord to completely rebuild a home, right, to accommodate you, but you know, you can ask them to put in reasonable aid so that you can access what you need to access. And so in the context of an emotional support animal, if you have an apartment building that has a policy that there are no pets, but you have an emotional support animal, you can request a reasonable accommodation to have your animal with you in your home based upon, you know, your disability. And the landlord can't deny that unless there are certain specific reasons.
Andrea, I had a quick question
Sure.
that I wanted to interject with. Does the fair housing, does that also apply to transitional housing, like homeless shelters, for example?
It likely would, because a lot of those agencies receive federal funding. So a good litmus test is if you're receiving federal funding or federal grants, the Fair Housing Act is going to apply to you. It really only doesn't apply to those very limited examples. So yeah, if you're in a shelter and right, I'm sure this comes up a lot. If you have an emotional support animal, which I think a lot of our homeless population does, I think there's an argument that you can't be denied shelter space because of your emotional support animal, as long as the request is reasonable. Now, I know a lot of those shelters have like communal living spaces. If you have someone who's deathly allergic to cats and another person with a emotional support cat, that might be a tough call for the shelter. But I would think that the Fair Housing Act would apply to transitional housing as well as shelters. But they have a little bit different parameters that they're working with because of the nature of that kind of housing.
Okay, thank you.
Yeah. Okay, so going into the process for a reasonable accommodation request for an assisted animal. So what you would need to do is submit a letter to your landlord from a treating medical provider stating why the animal is necessary for your disability. So I'm a very technical person. I'm an attorney, so I want to make sure like this is correct. I guess one thing that I really want to stress to people is the person that writes your letter does not need to be the treating medical provider. It just has to be someone who's familiar with your diagnosis and what the animal does for you. So let's say I have a clinical diagnosis of anxiety that I received from a psychologist, but I get a letter from my licensed professional counselor that I need a service animal. That licensed professional counselor may know why or not a service animal, that I need an emotional support animal. So that counselor may know specifically why or what that emotional support animal does for me and my anxiety, but she's not the one who is actually able to diagnose my anxiety. So she can write the letter saying this is what the animal does, but she cannot explain or give the diagnosis to the landlord. So I think the best practice is to have it come from your treating medical provider, because the person that's not the treating provider can't discuss the diagnosis, right? Like my counselor can't discuss the diagnosis that I have from my licensed psychologist of, clinical anxiety. So I would need to, in that instance, provide essentially a letter from my psychologist saying Andrea has chronic anxiety, and then also a letter from my licensed professional counselor saying Andrea has anxiety. I found out about this from Karen Weller, but this is what her emotional support cat. So that is a lot more hoops for someone to jump through. I think if you have the letter from the counselor, that's a good place to start. If that's the only thing you're able to get, I think give that to the landlord and see what they do. But technically they could say, well, I need a documentation of your diagnosis as well. So I understand that the people that, your primary care doc or your psychologist, if you're even able to find one in the Valley, they're very busy. And so it may be hard to get them to sit down and write these letters for you. So, you may need to go that route. You may need to just have a letter from them stating, yes, Andrea has clinical anxiety, and then a letter from your counselor that says she has clinical anxiety and she needs an emotional support cat, and this is what the cat does for her. So to that extent, you social worker write a letter for you. You could have your licensed counselor write a letter for you. Individuals that aren't necessarily capable of giving a diagnosis, but in that situation, I think you would probably also need or could be asked for a letter from the person who diagnosis or who's treating you for the diagnosis. So I just kind of wanted to make that distinction. I think the best practice is to get a letter from your clinical provider. If that's not an option, try the second best practice. No, if the landlord says, well, that's fine, but I need a documentation of your diagnosis, they're entitled to ask for that. So you don't have the same level of deference as you do with the service animals. So, my advice is always, if you're moving places and you know this place has a no pet policy, before you apply, tell them you have an emotional support animal, give them the letter, give them the documentation. If they deny your request to rent from that unit based upon the fact that you have an emotional support animal, then you have some recourse against them. But I hate for people to be in, I've litigated cases like this, and it's tough because county court judges don't do federal law. So you really have to do a lot of work to educate the county court judge on what the Fair Housing Act is. But I've had people that have been, evicted for having an emotional support animal and not clearing it with their landlord, or not being able to meet that burden after they've gotten an eviction notice, right? Like if you get a notice for a lease violation, you don't cure it, and you end up in county court, you've got 2 weeks to produce that letter from your medical provider saying, this person needs this. And I know how medical providers work. They don't have necessarily always a quick turnaround. So my words of wisdom, or my advice for people, is to kind of plan ahead about that kind of stuff. Don't just assume, I have an emotional support animal, they can't do anything to me. You don't want to end up in eviction court, I guess, is what I want to kind of caution people again. I definitely think there are a lot of people out there that do have emotional support animals and aren't aware that they're entitled to this protection, especially in this area. I've never had so much trouble trying to find a place to lease with a pet personally. I think there is a lot of discrimination against pets here, and like an unfair perception that pets destroy places, and that's not always warranted. But I would just encourage people to make that known to your landlord before you move into a new place. Okay, so if you do your reasonable accommodation request, you give the landlord the letter. They can't deny the request if the request is supported by reliable disability-related information. So it's supported by the person who gave you that diagnosis, or who's treating you for that diagnosis. And then if, again, going back to the service animal request, if the disability and the need for the animal were not apparent. So if it's apparent that and this is just for emotional support animals. If you have a service animal and the need for that animal is apparent, you can't be denied housing because you have a service dog. So that, you don't even need to do a reasonable accommodation request for a service animal where the need is readily apparent. You're not required to submit a letter to your landlord for your seeing eye dog, for your seizure dog, anything like that. You're permitted to have the animal. End of discussion. They can, so a landlord can deny a reasonable accommodation request if granting the request would impose an undue financial or administrative burden on the housing program. I think that would be hard for them to establish if, it's just a request to have, a cat with you. I don't know how they would be able to show that would cause an undue financial and administrative burden. The request would fundamentally alter the essential nature of the housing provider's operations. So again, Ashley, you're talking about transitional housing or shelters. If you have someone who has, an emotional support cat, that would essentially prohibit them from allowing anyone to have allergies. So maybe, they could say, well, yeah, this does apply to us, but we're going to deny the request because it wouldn't let us have communal sleeping, right? And then the specific assistance animal in question would pose a direct threat to the health or safety of others. So again, if someone else in the shelter was allergic to cats, and there's no way to make the reasonable accommodation that could eliminate or reduce the threat. So one thing that I want to really discuss here is it has to be specific to the assisted animal. So your landlord can't say, you can't have an emotional support pit bull because pit bulls are dangerous, and everybody knows that they're dangerous, and I'm not going to allow pit bulls. So it has to be like, this specific animal is aggressive, not, oh, we don't allow pit bulls. The request would result in significant physical damage to the property or the property of others despite any other accommodations. So you can't have an emotional support rhino in, you know, a 2-bedroom apartment, right? I think, so that's pretty broad. I've had all kinds of animals be considered reasonable assistance animals, and as long as, they're well trained and, kept up and comply with all the rules, it's fine. So this is important to know. So if the request is approved, the landlord cannot charge a pet deposit or pet rent. So that's not a reasonable accommodation. The reasonable accommodation is all of the same rules apply to you as they apply to everyone else, except that you're allowed to have your assistance animal with you. So saying, yeah, you can have your assistance animal with you, but you have to pay an extra $15 a month in pet rent, or you have to give me this non-refundable $500 pet, that's not a reasonable accommodation, because that's imposing extra things on the person with the disability. So you can't charge pet rent or extra fees. And you can't impose any requirements on the emotional support animal that aren't imposed on other tenants. So like, you can't say, okay, well, because you have a dog, you have to water the lawn now for like the entire complex, right? Because I don't want your dog to ruin our grass. Things like that, they can't do. Okay, so the tenant's responsibility. So tenants can't just say, I have an emotional support animal and then nothing more. You have to take care of your animal. You have to take them to the vet. You have to clean up after them. If you're a dog owner, you have to make sure that the dog poop is cleaned up, that they don't destroy the lawn. You have to make sure that your animal doesn't pose a threat to other animals. So if you have an emotional support dog and it attacks another dog, you can be evicted. Because you didn't keep that animal under control, it posed a threat to another animal. You have all of the same rules and responsibilities as any other pet owner in the world. The rules aren't different just because it's an emotional support animal. You have to retain control over the animal, and it just says control. So if your dog responds to voice commands, doesn't necessarily need to be on a leash as long as they're responding to those voice commands. And then even though the landlord can't require you to pay a pet deposit, if your pet does ruin the carpet when you move out, you can be required to pay the cost of replacing the carpet. Okay, what to do if your request is denied. So you can file a complaint with the Department of Housing and Urban Development under the Fair Housing Act. They have an online application, or you can call. Locally, Disability Law Colorado handles a lot of these kinds of cases too. If you're getting evicted because of your emotional support animal, you should 100% call me. But yeah, if your request is denied, you have recourse through the Fair Housing Act and the Department of Housing and Urban Development. And you should contact Disability Law as well. They handle a ton of cases dealing with discrimination based upon a disability. Resources. So we're here. I do eviction defense. You have to have an application, and we have to do a conflict check before I can give anyone legal advice. I generally don't handle landlord eviction. So if you own the property and you're trying to evict someone, I don't normally do that. U.S. Department of Housing and Urban Development has really great resources on the Fair Housing Act, and Disability Law Colorado also has a ton of great resources, and on discrimination based upon disability in general. They're a wonderful resource for folks. So that was my presentation. I'm happy to take any questions that have come in since we've started.
Yes, Andrea, we do have one question that came in early on Facebook, and that question is, what would you define a trained animal for both service and therapy, because I need both?
Well, okay, so therapy animals are, so they're defined as something different. So therapy animals are not, they're not trained for a specific person. And I'm talking about how the law defines them. In clinical practices, they may use those words interchangeably. But how the federal law defines them, therapy animals are animals that have like general therapeutic training, but they're not trained to the needs specifically for one specific person. So the most common example is like, they have like therapy dogs that they bring into the hospital, into like the children's wards. And those dogs are allowed to go into the hospital and, you know, visit with, you know, really sick kids because they have special training as a therapy dog, but they're not trained to provide a specific service to one specific person. If you have a disability and you need a service animal to assist you with that disability, then you know you need to go through the training to have an animal specifically trained for you. But maybe that your provider is using those two terms interchangeably. But as the law defines it, therapy animals aren't trained for one specific person. I know the Dumb Friends League has a lot of really good funding and resources for people that are looking to get the animal or need some assistance with funding for that. So I know that's a really good resource for people on the state level.
And I think, Andrea, too, I just wanted to say a good way to think about therapy animals is that oftentimes they work with a therapist or a counselor or a social worker. And like you said, they're going into hospitals or going into youth correctional facilities, or they do private practice with their, with the dog does the private practice with the therapist. So I know I hear that a lot too. There's a lot of confusion between therapy animals, but I think when people say they need a therapy animal, they may be referencing that they need an emotional support animal. Is that do you think that's accurate?
Yeah, I would. Another great example, I was just thinking about, the DA's office has funding for the victim services dog, right? That will go, and when we were having hearings in person, you know, can sit with the victim on the witness stand and provide support while that person is testifying. So that's a perfect example of a therapy dog. But they're not specifically trained for that specific witness. They're just there to provide that. And they're working with someone who's trained, you know, to help with that assistance. So it perhaps people are using that interchangeably with emotional support animal or assistance animal, which they're not specifically trained, right? So assistance animals aren't required to have, you know, specific training. You know, it can just be that, you know, I have clinical depression and my cat is, you know, gives me a reason to get up in the morning because I know I have to feed her, and, you know, she makes me feel better when she's running around like a crazy lady, or so yeah, I think that's a good definition.
And that is all the questions that we had submitted on Facebook. Andrea, thank you so much for presenting this. Andrea or Ashley, do you have any closing thoughts for anybody who might be watching this now or who might visit this webinar in the future?
Just if anybody has questions, the resources, I mean, feel free to call, of course, Andrea at Colorado Legal Services. If you have, or even call Roice-Hurst, and we can definitely point you into the right direction. We, you know, like to be a resource for the community as much as we can.
And Ashley,
absolutely.
Do you want to quickly just mention a little bit about our short-term boarding program for people in situations of crisis, so that people who might find themselves in a situation of transition and intend to, you know, move with their animal, but perhaps haven't notified their landlord to give that reasonable time period yet, what exactly the process is and how that program works?
Yeah, so we have a short-term boarding program at Roice-Hurst. It's up to 30 days for qualifying individuals. So we do have an application process. because again, we want to make sure we're helping people who may not have a ton of resources and love their pets and want to keep their pets, but maybe just going through a crisis or a transition. And so this program is really designed to help, keep pets with their people. And to access that, you can call me at Roice-Hurst. You can ask for Ashley, and I'd be happy to walk you through how to fill out the application and see how we can best help.
That's a really great resource for people.
And thank you both
Yeah,
for putting this together tonight and all of your efforts to keep pets and people together and protect people's rights when it comes to their service animals, their emotional support animals, and their pets.
Yes. Well, thanks everyone. Thank you again to Andrea and Colorado Legal Services. We appreciate you guys so much and for all the wonderful work that you do.
Yeah, we appreciate you guys too. I'm quite in love with my little orange cat that I got from Roice-Hurst. So.
Oh.
All right.
Wonderful. Well, everyone have a good night and thank you for joining us. Yeah, I think we'll end.